The House will now come to order. And with the Pledge of Allegiance this morning will be led by three important guests, Alina, Thalia, and Isidoro Gutierrez, who are the children of our own State Representative, Serena Gonzalez Gutierrez.
Please join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, with liberty and justice for all.
We do?
See the yellow.
All right. That's Isidoro.
Thank you.
Mr. Shebo, please call the roll.
Representatives Amabile. Representative Amabile. She's here. Oh. Bacon. Baisley. Benavidez. Burnett. Byrd. Bockenfeld. Basenecker. Bradfield. Caraveo. Carver. Catlin. Cutter. Doherty. Duran. Esgar. Exum. Froelich. She's here. Geithner. Geithner is excused. Gonzalez Gutierrez. Gray. Hanks.
Here.
Herod. Holtorf. Hooten. Judah. Kennedy. Kip. Larson. Lindsay. Fontaine. Luck. Lynch. Representative Lynch is excused. McCluskey.
Here.
McCormick. McKean.
41.
Hey. McLaughlin. Michaelson Janae.
Present.
Mullica. Neville. Ortiz. Pelton.
Here.
Pico. Representative Pico is, Ransom. Rich.
Morning.
Ricks.
Very much in the mood already.
Oh, no, because I have to go. Are you going to do family today?
Representative Ricks is excused. Roberts.
Here.
Oh, he's present. Sandridge.
Here.
Sirota. Snyder. Soper.
I didn't have to burn my joke. I was late, so I didn't have to burn my joke.
Yeah.
Not up there. Rep Soper
I mean, if it's real good, you can still do it.
is excused. Sullivan. Tipper. Titone. Valdez A.
Here.
Valdez D. Van Beber. Van Winkle, Weissman, Williams, Woodrow, Woog, Young, and the speaker is excused.
What? All right. Thank you, Mr. Sheba. We have 60 present and 5 excused, so we met the quorum requirement this morning. I know everyone's excited. All right. So the next order of business is the approval of the Daily Journal. Representative Doherty. Representative
Thank
Doherty.
you, Madam Chair. I move that the Journal of Thursday, March 31st, 2022 be approved as corrected by the Chief Clerk.
And members, you've heard the motion, and you recognize she was late in getting up here, so it shows her sincerity. So you've heard the motion, and so now before us is all in favor, say yes. All opposed, say no.
No.
Well, the heart of the yeses were there, so we will go ahead and say the motion passes. Gavel. We're doing announcements and introductions. Representative Harrod.
Thank you, Madam Chair. Members of the Appropriations Committee, we had jokes this morning, and they were really actually very, very good. And while I'm so sorry I can't give everyone the award, I am going to give the award today to Representative Exum. Come on down. And you guys will see why very soon.
Representative Exum.
Thank you, Madam Speaker Pro Tem. I mentioned this morning to Madam Chair of Appropriations that I had a dream about her. But it was just my imagination running away with me.
All right, that was deserving of the win.
Battery will get you everywhere.
All right, let's continue on with announcements and tributes. And we have a tribute, and I'm going to recognize Representative Amable and Representative Larson. Members, this is a tribute, so if we could pay attention.
Good morning. Good morning.
Representative Amable.
Good morning, members. Rep. Larson and I are here this morning. We actually have a serious thing, and then we'll let you get on with the levity of April 1st. But we're here to pay tribute to Child Abuse Prevention Month, which starts today, and we have a tribute that we would like read.
Mr. Schiebel, please read the tribute at length.
State of Colorado. The House of Representatives convened in the 73rd General Assembly hereby recognizes April as Child Abuse Prevention Month. Each and every one of the 1.2 million children in Colorado deserves to be valued, healthy, and thriving. All parents and caregivers need support, but some families, more than others, experience social, economic, and environmental inequities. Certain conditions in our state, such as where people live, learn, work, and play, affect a wide range of health risks and outcomes, including child abuse and neglect. Childhood trauma can have long-term psychological, emotional, and physical effects that have lasting consequences for victims of abuse. Parents, caregivers, families, friends, neighbors, employers, and elected leaders must collaborate to prevent child abuse, strengthen families, and build brighter childhoods. We must work together as a state to increase awareness of how to prevent child maltreatment and promote the social and emotional well-being of children and families in safe, stable, and nurturing environments. The Colorado House of Representatives hereby proclaims April as National Child Abuse Prevention Month in Colorado and is dedicated to improving the quality of life for all children and families. On request of Representatives Judy Amable and Colin Larson, given this first day of April 2022, State Capitol Denver, signed Alec Arnett, Speaker of the House of Representatives.
Thank you. Representative Larson.
Thank you, Madam Speaker. or Madam Chair. Members, today or this month is Child Abuse Awareness Month. As you notice, many of us are wearing blue, and you all have a pinwheel on your desk that is to commemorate this month and to just remain in the back of our minds as we move forward with this almost last month of session, to remember the priorities here and to focus on the real things, things that we can really have an impact here and address child abuse. So with that, I will hand it over to Representative Mobley.
Representative Amabile.
Thank you, Madam Speaker Pro Tem. So, yeah, as Rep. Larson mentioned, you have these pinwheels on your desk, and I think that's to remind us of, it's a symbol of a happy childhood. And I think we all know that here in Colorado and everywhere across our state and across the country, not every child has a carefree and happy childhood. And it's important part of the work here, probably the most important part, that we try to make that happen for as many kids as we can. So our friends at Illuminate Colorado, an organization and that works to strengthen families, organizations, and communities to prevent child maltreatment. Illuminate has organized a wide range of activities and outreach throughout the month to remind us that taking good care of Colorado's children is key to a strong future in our state. And I think you all have been getting emails inviting you to various things, which I would encourage you to attend. As you heard in the tribute, more than 1.2 million children in Colorado today, and every one of them deserves every opportunity to grow up healthy and with all of the opportunities our country promises. Child abuse and neglect are serious problems affecting every segment of our community. Actions we take in this body make a difference and impact the well-being of our children today and into the future. So thank you very much. Thank you.
Did you want to talk about anybody else? No? Okay, thank you. Then I'm still on announcements. Representative Gray.
Thank you, Madam Speaker Pro Tem. I just want to note that today is the 506th Friday since Alex Sullivan was murdered in a shooting that we all know very well about, but we also haven't done everything with respect to gun violence, so we need to address it. And today is number 506, and we should keep doing the work. Thank you.
Thank you, Representative Gray. Representative McLaughlin.
That's it. Getting short. Mine's a little different today. I just want to thank everybody who has voted or sponsored bills addressing mobile home parks in Colorado, because as of, okay, yes, Edie Hooten. Yesterday, our second park in Durango was able to buy their own. They had help, but they get to buy their own trailer park. And these people have been living there for a long time. Their trailers are so old that when the park went up for sale and their rent was going to be raised or they would have to move, most of the trailers would have fallen apart if they had moved them. They were just so old. And now these people who are low-income Coloradans get a place of their own. Their rent is not going to go up. They have been given pride, they have been given community, and they have been given dreams that they get to reach. And I'm so, so happy. So thank you for all of you who have done that. It's really good work. And this is our second one in Durango. So affordable housing is a possibility in Colorado. So thank you.
Thank you for that good news of the day, Representative McLaughlin. Representative Lindsay.
Thank you, Madam Speaker Pro Tem. I have some special guests here. I just want to recognize them over here on the right. My family's on spring break this week, so I brought them today. My husband, Kevin, is there. My son, Ewan, daughter, Penny, son, Tristan, and then his girlfriend, Nina. They're here watching our business today. So please welcome them and I'm so glad they get to meet you all. Thank you.
Thank you. Representative Froelich and Representative Will. And many others, but let's start with Froelich.
No, it's a different one.
Representative Froelich.
Thank you, Madam Speaker Pro Tem. We have a resolution that we would like Mr. Shebel to read.
Is it, Representative Froelich, is it a tribute or a resolution?
It's a resolution.
According to the Majority Leader, it's a resolution. So we should read it at length?
Yes.
Is that what you've requested? Okay.
A resolution to address the urban-rural divide. The Colorado House of Representatives hereby finds that today and today only, in order to bridge the rural-urban divide, we will rename the machine the barn door. Therefore, the instructions from the Speaker for today, April 1st, will be, Mr. Shebel, please open the barn door, and members, please proceed to vote.
Representative Froelich.
Madam Speaker Pro Tem, I move for a voice vote.
Is there any objection to a voice vote? Okay. So, with objections, then we will open the machine. This resolution has not passed, and I'm not the speaker. So, we will open the machine and members proceed to vote.
No, I withdraw the motion.
Okay, members, you don't have to vote. The representative has withdrawn the motion and the resolution. All right, are there other announcements? Well, Representative Catlin's hand went up first.
Thank you, Madam Speaker Pro Tem. It's an honor to serve with you.
Honor to serve with you as well, sir.
Thank you. You know, with this resolution, maybe we should also say it's too late. The horses got out of the barn, so there's no point in doing it.
Well, and that comment's a little late since it was withdrawn, but okay. Representative Gray again.
Again, thank you, Madam Speaker Pro Tem. I have another resolution here that I'd ask for it to be read at length with my colleagues.
Is that a resolution or a tribute?
It's a fake resolution.
Okay, let's read the resolution at length.
Whereas, in the Colorado General Assembly's constant debate over the urban-rural divide, the suburbs are always forgotten. And whereas our urban and rural counterparts think the suburbs are fine to visit when they need to shop at Sam's or Costco, but otherwise look down on them. And whereas the ubiquity of Applebee's means it is named the official state restaurant. And whereas homes in the suburbs feature large lawns and tall fences to hide from nosy neighbors. And whereas next door is where you learn that you really don't know your neighbors at all. And whereas it is universally acknowledged that minivans are the best mode of transportation. Yeah. And whereas who needs public transportation when you have the privilege of hopping into your sweet, sweet ride to get everywhere? And whereas keeping up with the Joneses is an Olympic caliber sport. And whereas Bunko is the official Colorado dice game. I'm familiar with that.
Bunko.
And whereas an urban and rural dead end is a suburban and far superior cul-de-sac. And whereas khaki is an excellent choice for both pants and skirts. And whereas the Colorado economy is supported through the purchase of Lululemon and other yoga apparel by people who do not know the difference between a welcome mat and a yoga mat. Whereas living in the suburbs means there's an abundant supply of soccer fields and a trophy for everyone. And whereas the PTA is your beer pong league all grown up, and paying your HOA dues is as important as paying your taxes. And whereas communities become more vibrant and inviting with a Target, Supercuts, Chipotle, Starbucks, and Barnes & Noble located within 3 miles of wherever you are. And whereas the burbs originated the phrase, "Get off my lawn, I'm telling the HOA, and stop your dog from pooping in my tulips." Therefore, be it resolved by the House of Representatives on this April Fool's Day 2022 that when acknowledging the geographic diversity of our state, we should not forget that the suburbs literally span the divide between urban and rural Colorado.
Representative Gray.
Thank you. We spend a lot of time talking about the rural-urban divide, and when I was putting on my sandals while wearing socks the other day, I was thinking you could build something in between. You could bridge the gap in between, create something that's not quite rural or not quite urban. And then I realized that magical gift was already here, and we are all here to tell you that when you want to bridge that divide, we'll be here for you because we are physically in between both of you, and we're the middle child that can solve this problem.
Representative Froelich again.
Thank you, Madam Chair. And, you're welcome, Colorado, because without, we would not need any managers at all in Colorado if it weren't for us asking to speak to the manager.
All right, well, I'm not hearing any request for,
Please.
okay. So, that resolution has been withdrawn. We're 2 for 2. Representative Holt or Madam Majority Leader.
Thank you, Madam Speaker. Just a quick question for that resolution group and sponsors. Working up here for the past 8 years, I'm really confused as to where Pueblo sits when it comes to the rural-urban divide. We're not really suburban, but we're urban when you want us to be, and we're rural when you want us to be. So I'm just real confused on where Pueblo sits on this resolution. I don't know how to vote. I'm glad you withdrew it. Thank you.
Representative Gonzalez Gutierrez.
Thank you, Madam Speaker Pro Tem. Members, I just want to make sure that I am present now for roll call. I think there was an imposter in the House this morning, and even posing as my children's mother. My kids are here. They did the pledge, so I just want to welcome them, Isidoro, Talia, and Elena.
Representative Holtorf and Representative Pico. Holtorf first.
Won't go too high. Thank you, Madam Speaker Pro Tem. In all seriousness, I have an announcement. Today is National Bootleggers Day. National Bootleggers Day is recognized in an area when bootleggers became legendary, and I'll explain where the name came from. Templeton Rye Whiskey shares its birthday with bootleggers like Al Capone and the sons of another bootlegger, Merrill Kirchhoff. During the 1800s, the term bootlegger came into use in the Midwest and the West. The word described the act of concealing a flask of liquor in a boot top when going to trade with other traders. The term found its permanent place in the American vocabulary when Congress passed the 18th Amendment. Despite, particularly in this amendment, it prohibited the manufacture, transport, and sale of alcohol in 1920. Despite at that time being illegal, thirsty Americans still had a demand for their liqueur. So while some distilleries switched their production that was illegal, many of them began bootlegging in very remote places. Bootleggers helped fill the demand by smuggling various brews from Canada and Mexico, and also in some places in North Carolina, starting the NASCAR racing industry. Later, distillers in the backwoods and secluded areas brought their loot back to speakeasies and other establishments. Some are even known in the lore of Denver, Colorado. Okay, such terms as rum runners and moonshiners have become popular during this time. The legend of bootlegging grew to mythological qualities as the mafia rose out of the illegal and coordinated activities of bootlegging. Glamour, danger, and mystery surrounded the stories of names like Al Capone, Lucky Luciano, Alfonso Kirchhoff, and Muggs Moraine. 1933, Congress ratified the 21st Amendment, repealing prohibition and the noble experiment that appeared not to work.
Representative Pico.
Thank you, Madam Speaker. I'll drink to that.
And ladies and gentlemen,
just a second.
this is
Let me.
April Fools.
All right.
Now, the real day, if you want to know, you'll have to come and ask me later.
All right. Representative Van Winkle.
Thank you, Madam Speaker. And somewhere, Pappy Van Winkle thanks both of you very much.
Representative Michelson Janae.
Thank you, Madam Speaker Pro Tem. Live from the suburbs, Public and Behavioral Health and Human Services will not be meeting today, and this is no joke.
All right. Are there other announcements? Yes, Representative Lontine.
Thank you, Madam Speaker Pro Tem. Sadly, this is not an April Fool's joke, but the Health and Insurance Committee is meeting today. So yay us. We'll be in room 112. We're here 11:22 for action only, 12:46, 12:69, and 11:98. Please be there 10 minutes after adjournment. Thank you.
Are there other announcements or introductions? Hold on. We're going to have a very short recess. The House will come back to order. Mr. Schiebel, please read the reports of the committees of reference.
Committee on Appropriations, after consideration on merits, the committee recommends the following. House Bill 1133 is amended 1212, 1232, 1249 is amended 1261, 1265. Senate Bill 32 be referred to the Committee of the Whole with favorable recommendation. Committee on Energy and Environment, after consideration on the merits, the committee recommends the following. House Bill 1166 be amended as followed, and as so amended be referred to the Committee on Finance with favorable recommendation. Committee on Finance, after consideration on the merits, the committee recommends the following. House Bill 1254, Senate Bill 77 be referred to the Committee on Appropriations.
Thank you, Mr. Schiebel. Madam Majority Leader.
Thank you, Madam Speaker Pro Tem. Members, because it's April Fool's Day, and I hate that day, we're going to do things in a little bit backwards order. We're going to do thirds last today. We're going to start with special orders. So I move the following bills be made special orders today, Friday, April 1st at 9:33. Senate Bill 103, House Bill 1133, House Bill 1212, House Bill 1232, House Bill 1249, House Bill 1261, House Bill 1265, and Senate Bill 32. Basically, what was on seconds today and all of the appropriation bills that went through this morning.
Members, you've heard the motion. Seeing no objection, we will proceed into special orders. What? As requested by the Majority Leader and gavel again. And I recognize Senator Gonzalez Gutierrez. No, or she will chair the special orders. It's done. Please join us up here. Oh, gavel.
hold on. The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the majority leader, and the Cote rule is relaxed. Mr. Schiebel, please read the title of Senate Bill 103.
Senate Bill 103 by Senator Gonzalez, also Representative Tipper, concerning a remedy for improperly entered guilty pleas.
Representative Tipper.
Thank you, Madam Chair. I move Senate Bill 103.
To the bill.
Thank you, Madam Chair. Senate Bill 103 deals with a constitutional right that non-citizens in this country have to be advised of immigration consequences of their pleas. It is well known that prior to 1987, which was the Supreme Court case here in Colorado, and 2010, which was the U.S. Supreme Court case, that individuals entered pleas that were unconstitutional because they were not properly advised. So what this bill does is it creates a procedural mechanism for individuals to seek to reopen an entry of certain pleas. They're all non-VRA crimes. They're all non-Title 42, which are serious traffic violations. So it's a really narrow body of convictions that would have an opportunity to be revisited. So the remedy is just a rearrangement. With that, we have gratitude for CDAC, the Colorado District Attorney's Council, for CML and CA, the Municipal Judge Association, who helped get this bill to a good place and get the robust bipartisan support that we had in the Senate when it came over. With that, I do have one amendment to clarify one portion of the bill, and I would like to offer and move Amendment L004.
Amendment L004 has been moved.
Thank you, Madam Chair. And
Hold
this
on
came
one
out-
moment. Let me make sure it's displayed. And it is properly displayed. Please continue, Representative Tipper.
Thank you, Madam Chair. This came out of the committee hearing when we had a discussion about the reasons behind the ability to file a motion. So just to clarify, you have to be an individual that has had or would have suffered immigration consequences, and two, you have to allege sufficiently that the entry of that plea was done so without knowing the potential immigration consequences, which renders it unconstitutional. So with that, I ask for a yes vote on Amendment L004.
Is there any further discussion on Amendment L4? Seeing none, the question before us is the adoption of Amendment L4. All those in favor say aye. Aye. All those opposed, no. The amendment is adopted. To the bill, Representative Tipper.
Thank you, Madam Chair. With that, I ask for a yes vote on SB 103 as amended.
Further discussion, Representative Carver.
Thank you, Madam Chair. Members, Rep. Tipper is quite correct that the Supreme Court cases have made absolutely clear that the individual who is in the country undocumented, subject to deportation or other immigration consequences, that they need to be advised of potential immigration consequences if they are facing criminal charges, and then depending upon what they are found guilty of or plead guilty to, that may subject them to having to leave the country. I actually agree with the vast majority of this bill, except for the very last part. So what the bill provides is if an individual is now at risk of being deported because they unknowingly they went through the criminal justice system, and let's say they pled guilty to a certain charge, not knowing that that would put their green card or otherwise put them at risk of being deported. The process in the bill, which I agree with, is that they raise that by a motion making the allegations. The prosecution then must respond, and if they don't respond, then there is a process to go ahead and clear that. However, here's the part that I disagree with. Unlike citizens, when a citizen believes their guilty plea was done in a way that is constitutionally infirm, the citizen has the burden of proof in providing that proof in front of the court. However, what this bill would do is it would say that once the individual, the non-citizen, raises the issue, the prosecution challenges the initial allegation. In other words, there's a dispute on whether the individual was properly advised. And now we go to a court hearing. This bill would say that it is the prosecution, the government, that has the burden of proof in proving that the proper advisements were given. So I don't understand why a citizen who is trying to get a guilty plea thrown out as constitutionally infirm, they have the burden of proof in front of the court. But only in this case, when a non-citizen is challenging a guilty plea as constitutionally infirm, all of a sudden the rule is the prosecution has the burden of proof to prove a negative, and if they fail to do that, then it is automatically deemed that the guilty plea falls. So I simply cannot agree with that part of the process. I don't understand why we would have a rule that, if it was a rule equal with what citizens have to challenge constitutionally infirm guilty pleas, fine, but not this. So I'm a no on this bill.
Representative Tipper. Thank you, Madam Chair. Thank you, Representative Carver. Just to clarify a couple of things that were said. So it's not the case that just undocumented individuals would be subject to this. And I think in your comments you clarified that also individuals that are other non-citizens, so if you have a green card or an investor visa or any other type of lawful visa, you still can suffer immigration consequences. It's true that the burden is on the prosecution, but that's not unheard of. We heard in testimony that there are, in suppression hearings, which is when an individual is bringing forth a motion to suppress evidence that was obtained unconstitutionally, the burden is on the prosecution to prove that that's not the case. It's analogous situation here, and what it reflects is the severity of the consequences, the heightened standard of constitutional challenges. And it's not the case. I think the distinction between citizen and non-citizen is a bit unfair because not all guilty pleas are challenged just on constitutional grounds, right? So it's not that just because citizens who are challenging their pleas, who would never find themselves in this situation, that it's different standard for them. It's a different array of grounds for challenge. And finally, it's a recognition, and I said we worked with the district attorneys on this, it is a recognition that there are a number of cases dating back 2 and 3 decades where we know the plea was constitutionally infirm. We know that the plea that was entered is unconstitutional and absent some mechanism which recognizes the body of cases that fell into that category. We can't right the constitutional wrong. I ask for a yes vote.
Representative Carver.
Thank you, Madam Chair. And yes, to absolutely clarify, this can be non-citizens, whether documented or undocumented. But in federal immigration law, if you are found guilty of certain crimes, that can provide an additional basis for deportation. And that's the instance where the Supreme Court said that that is a requirement in our criminal justice system, that they be so advised, and quite frankly, that is an obligation of defense counsel as part of their ethical and legal obligation to so advise. And quite frankly, if they haven't, it's ineffective assistance of counsel in violation of the Sixth Amendment, to be honest. But the point here is that when I ask the question, is there any other type of motion where the burden of proof, when you have an individual who is challenging a result in the criminal justice system, almost always the burden of proof is on that individual to make the case. And I asked in committee, is there any other instance where the burden of proof shifts to the prosecution? And the only thing that was brought up was on when a search warrant was issued and it was done improperly. Well, to me, that is very different. If the government initiated the search warrant and now it's being challenged, of course the government has the burden of proof to show that they complied with the Fourth Amendment. That's not what this is. This is post-conviction appeals, post-conviction remedies. And across the board in post-conviction appeals, when you are challenging a guilty plea, it is the individual who has the burden of proof when it goes in front of a court. And I simply do not understand why, in a case of a non-citizen, the burden of proof, unlike a citizen, the burden of proof gets shifted to the prosecution to prove a negative, but for a citizen, they would have to meet the burden of proof showing that their guilty plea was constitutionally infirm for whatever reason. I just think that is not the right process. Again, I could support this bill if we left the burden of proof to do the same type of as a citizen. If the guilty plea was improperly done, if advisements were not done, there's all sorts of ways a guilty plea can be constitutionally deficient. Why not the same process? Ask for a no vote.
Madam Speaker Pro Tem Benavides.
Thank you, Madam Chair. Members, and I truly respect my colleague from El Paso County, and we had a long discussion about this in Judiciary Committee, and she's referring to Section 5B, but it's the whole idea of taking one part out of context from the rest of the bill. And the first part of that says that the defendant will make a motion, and if a response is not filed, then the motion is approved. If it is opposed by the prosecution will oppose the defendant's motion, and it has to allege in good faith that the facts upon which it bases its opposition. So they have to say why they oppose it. And if the response that they submit raises a question of material fact, then the court has to have a hearing on it. So the next part is, all of that has been done. So they've filed a response, they've said why they disagree. And then unless the court deems there's no issues of material fact, unless the prosecution proves by a preponderance of the evidence in that filing that the defendant will not suffer an adverse action or the guilty plea was constitutionally infirm, then they will enter judgment on the motion for the defendant. That's what this says. So in lots of cases, there's burden shifting. And the individual that brings it, and one example, and I didn't think of this in Judiciary Committee, but when you think of discrimination complaints, you file the complaint or the lawsuit and you establish what's called a prima facie case, that this happened to me and I believe it was because of discriminating acts by the other person, the employer, let's say. All you have to do is that, and then the burden shifts to the defendant in that case, the employer. And the employer has to say, nope, it wasn't that, it was something else. And that's why it wasn't discrimination. So burden shifting is not new. And I think this is a shifting of burdens when you look at paragraph 5A, when the information has been filed by both parties and the court is looking at that and making a decision. So, members, I think it is addressed in the bill, and I would encourage a yes vote.
Any further discussion? Representative Carver.
Thank you, Madam Chair. Respectfully to my colleague, and I mean, she's quite right in how she describes the three phases. The problem is not with the first two, the problem is with the third. So if you have the bill on page 4, you see the process. The non-citizen believes that they entered a guilty plea and it's constitutionally subject to challenge because they were not advised of the consequences. They make a motion that the guilty plea be vacated. The prosecution has an opportunity to either, if they concede the point, then the motion goes forward. The prosecution is silent. If the prosecution believes that the motion is not proper and that the non-citizen was advised, then they respond to the motion and challenge the motion and allege facts showing in good faith why the guilty plea should not be vacated. I am fine with those two sections. It's only when we get to the third step, which starts at the bottom of page 4 and then takes up half of the next page 5. Unlike a citizen who is challenging a guilty plea as constitutionally infirm, what a citizen would face going into that court hearing is they would have the burden of proof to prove facts showing that the guilty plea had a constitutional defect. I confirmed this with the DA Council, that post-conviction appeals, including challenging guilty pleas, the burden of proof is on the individual citizen. So I simply do not agree with a process for a non-citizen to not follow that same process and instead make the government have the burden of proof. We're talking about cases that could go back a number of years. The other thing that was in that third step is it also puts some parameters around how the prosecution can meet its burden of proof. So I just think I don't understand a process that where we specifically make the process different and much easier for a non-citizen challenging than a citizen. It simply makes no sense to me. And then also put restrictions on how a prosecution can even meet their burden of proof. Why are we making different rules? Ask for a no vote.
Any further discussion? Representative Bockenfeld.
It's an honor to serve with you, Madam Chair.
It's an honor to serve with you.
I think Representative Carver made some very, very strong points. We talk a lot about equity. We talk a lot about equality. Well, then we come right in and we create a bill that goes against equity and equality. Why are we creating a bill that has a different standard for one class of people than another? It's not appropriate. And I think we're at a point where we need to start looking at some of this legislation and taking it seriously. I think we need to take our role seriously here at the legislature and how we approach these bills to make sure those elements are in each and every bill. If we're going to talk the language, we need to walk the talk. And that's not what we're doing in this case. Ladies and gentlemen, it's time that we strike a balance on these issues. I ask for a no vote on this bill.
Any further discussion on Senate Bill 103? Seeing Representative Luck.
Thank you, Madam Chair. So I just want to make clear the objection is in no way as relates to the need to address this issue, right? We understand that these are rights that have to be honored and that we need to come up with a solution for this. The question is, what is the best process to do that? And so the only part, as was stated previously by my colleagues, that is in question is who should bear the burden of proof. These cases span decades. We're not talking a case that came last year. We're talking cases that came in the 1970s or the 1980s. And to put the burden of proof on the prosecutor is, I believe, an unjust burden. The moving party is most aware of the situation, has the greatest degree of knowledge about the situation, and should be the one to fully present the case to demonstrate why it is necessary to go back to square one and re-engage from there. I thank you for hearing us out and appreciate if you have any.
Representative Tipper.
Thank you, Madam Chair. So first off, the reason this is a different situation because citizens cannot find themselves in this situation. So we're not pitting non-citizens against citizens. And again, it is burden shifting. It's not that the individual bringing the motion doesn't have a burden. They do. They have to plead the unconstitutional elements. And the burden shifts, which we see across different areas. Not to continue to belabor the point, but I think to say that this is setting up a different standard for citizens than it is for non-citizens is really unfair. Because citizens will never find themselves in this position where their constitutional rights were violated, in some cases intentionally. And it's a recognition of that. And to the extent that the DAs are upset, they never said that. They never said this burden is insurmountable, the burden shifting in this bill. They never said, we can't do this. They supported the legislation. They were neutral on the legislation and helped us get this bill to the place that it is today. I ask for a yes vote.
Further discussion, Representative Carver.
Thank you, Madam Chair. Well, of course, when you're talking about doing a challenge to a guilty plea, and I say this as somebody who practiced as a defense counsel, there are a number of bases where a guilty plea, in fact, can be found constitutionally infirm. And a lot of times, quite frankly, it's where the defense counsel is screwed up and not done their job. And so, in the situation of a non-citizen, it is certainly true that the advisement on the consequence of a guilty plea may be unique to the non-citizen and provide an additional basis in this regard. But that's not the basis for my opposition to this part of the bill. There is simply no good policy reason to require the prosecution to have the burden of proof when in this case, for a non-citizen, then when a citizen who is challenging their guilty plea as being entered in a way that violates the Constitution would have the burden of proof and not the government. And then, in addition, to write into the bill restrictions on how the prosecution can meet their burden of proof. So that is why, members, I would offer L006 and ask that it be displayed.
Amendment L6 has been, can you move the amendment, Representative Carver? You offered it, but can you move it?
Yes, thank you, Madam Chair. I move L006.
Thank you. That is a proper motion. Amendment L6 is now before us. Please continue.
Thank you, Madam Chair. And this would simply strike the word prosecution and substitute the word defendant, so that should this go to a court hearing because there is a dispute, the defendant has the burden of proof to show that, in fact, his or her guilty plea is constitutionally infirm. Ask for an aye vote.
Is there any further discussion on Amendment L6? Representative Tipper.
I ask for no vote on Amendment L006. For all the reasons we've talked about, this is a burden shifting that's been carefully negotiated in recognition of the extreme circumstances that individuals find themselves in when their pleas were unconstitutional, a circumstance that a citizen could never find themselves in. So we're comparing apples and oranges. When non-citizens challenge pleas under all the other grounds that are available to citizens, they're subject to the same. It's just in recognition of this extraordinary circumstance. I ask for a no vote.
Is there any further discussion on Amendment L6? Seeing none, the question before us on the amendment. Okay, Representative Luck.
Thank you, Madam Chair. So just really quickly, are there time frames, do you guys know, are there time frames for a citizen to plead unconstitutional infirmity that are similar? I mean, if we're arguing that these things are apples and oranges, or that we're treating, I'm just wondering, is there a time frame that is put on citizens to challenge the constitutional infirmities of a guilty plea that we're not having here?
Representative Tipper.
Yes, there is a time limit, which is the carve out for these circumstances is in recognition that in 1987, the Colorado Supreme Court said it's unconstitutional not to advise individuals of potential immigration consequences. In 2010, the U.S. Supreme Court said that. So cases that occurred before the Supreme Court's ruling are time barred. Again, and we're talking about cases that are limited to the passage. If this bill passes, that cuts it off. So we're talking about cases filed before that in recognition that this is an issue in the past. It's not an ongoing issue, but because of the time bar, these individuals cannot vindicate their constitutional rights that are recognized regardless of whether you're a citizen or not. But if you're not a citizen, you have this issue. If you're a citizen, you don't.
Representative Luck.
Thank you, Madam Chair, and thank you for that answer. So then, even more so, I think that this amendment is a good amendment, because what in essence you're saying is that we have these two classes of people in two different situations, but both of them can find themselves in a situation where they pled within an environment of unconstitutionality, right? But as a citizen, there is a time frame by which you have to challenge that. This bill says to those who are non-citizens that
that there's no longer the time frame. We want to open up all of this. We want to right this wrong for all of you, regardless of the time frame. Great, wonderful. But then let's make sure that the burden is on the party that knows the most, which in this case would be that non-citizen actor who would be able to meet those standards at a much higher rate. They would be able to meet those standards much easier than the prosecutor would be able to meet that standard. And so I think that while I understand what you're saying, that there are already differences inherent in citizens and non-citizens, there is already carve-outs that we're not objecting to in treating non-citizens differently. But on this one point, we would ask that the burden shift to the prosecution, which, just really quickly, is different than in other situations where things like the motion to suppress is shifted back to the prosecution, because in those instances, the prosecution had control over that environment. And in this bill, in many ways,
I want to just, I'm sorry, Representative Luck. I just want to make sure we are on the amendment, because I keep hearing this bill, and I just want to make sure we're actually talking about the amendment. If we're ready to move on from the amendment, we can definitely do that. Okay,
thank you, Madam Chair. No, this bill, this amendment, that standard to switch it to the defendant or keep it with the defendant, I think is consistent with other areas, because the prosecution doesn't have the same degree of knowledge and investment as in situations like the motion to suppress.
Representative Tipper.
Thank you, Madam Chair. The initial burden is on the non-citizen to plead this motion, period. The initial burden is on the non-citizen defendant. This is just for narrow cases that involve immigration consequences and a constitutionality tied to not being advised of the constitutional requirement that there could be immigration consequences. So that's why I'm saying comparing this to all other challenges is apples and oranges, because the citizen would never find themselves in this situation. And again, to the extent that there's a suggestion that the burden is not on the individual who has the information, that's not true. The initial burden is on the individual. If they meet that burden, there's a shift, which is not unheard of. I fear that we're just going to go round and round in circles, so please don't interpret my silence as rendition. I feel very strongly that the burden shifting is absolutely appropriate in these extraordinary circumstances with individuals who are denied their constitutional right absent. And if we invert it the way that my colleagues are suggesting, you're going to continue perpetuating the injustice and the unconstitutional pleas that are entered. I can't live with that. I can't sleep with that.
On Amendment 6, Representative Carver.
Thank you, Madam Chair. And, you know, I have the greatest respect for my colleague, Representative Tipper. I just must respectfully disagree. Let's be clear what this amendment does and does not do. It makes one change in the third step of the process. It says that if you end up going to court because there is a dispute, burden of proof is only in the court hearing, the third step. So I would be perfectly fine with a process, and let me just say that there is again, there is no question that an individual, if they did a guilty plea and they didn't get advised of immigration consequences, that is a constitutionally infirm guilty plea. Agreed. There absolutely must be a process to address that. Agreed. But the process to do that is, quite frankly, the exact same procedural process as for a citizen, which is the individual brings a motion to challenge the guilty plea. The prosecution looks at the motion, and if they believe that, no, the guilty plea was properly done, they challenge the motion. Then it goes to court. Only in the third step is there a burden of proof in front of the court. And in all other cases, quite frankly, not even just limited to citizens, but in all other challenges, post-conviction challenges, the burden of proof is on the individual. That's all this amendment does, is that we should not carve out a special rule that says the prosecution, under these restricted rules of evidence now, which is also in the bill, has the burden of proof of basically proving a negative, when in all other cases, that would be on the individual, especially when the knowledge of what the individual was actually advised is held by the individual and the individual's defense counsel. Right? That's who has the knowledge. That's generally where the documentation is going to be. That's where we also heard testimony that means that the defense counsel's records are probably going to be subject to a subpoena, because the attorney-client privilege will be waived. If the advisement wasn't done, it's because the defense counsel screwed up. So that is why I think this is an appropriate amendment. With the amendment, it provides that process for an individual to be able to challenge a guilty plea that was done without proper advisement. With the amendment, it provides a process that is workable for these individuals where they did not get the proper advisement. Ask for an aye vote on L006.
Madam Speaker Pro Tem Benavides.
Thank you, Madam Chair. And members, I urge a no vote on this amendment, and I'm going to explain to you why. I don't think this does what the proponents have said it will do. Remember, this bill is about giving people the opportunity, if they were not properly advised, only for municipal ordinance, misdemeanors, court rules, those kinds of things, not for felonies. These are just the smaller types of crimes. If any of you have been charged with anything like that, a municipal violation, could be some traffic offenses, they could be other things, small crimes. And the advisement, many people are pro se. They don't have attorneys that advise them. Most of those advisements come directly from the court. Oftentimes, especially in municipal courts, they may show a little video. When the defendants are there, they all watch it. They may get a handout of their advisement. Or the court may read the advisement at the start of the court proceeding, because it's a bunch of people coming in at once. It's not individual trials that are happening. And people go ahead and they plead guilty to these because partly it's not worth the fight to do it, and they just pay the amount. It's not till later that they understand the impact on their immigration status. And the bill lays out, starting on page 3 at the bottom, what the defendant has to show in their motion. They have to make a showing of all these things. I'm not going to read it to you, but it's the first half of page 4. That's what they have to show. They have that burden of showing those things. Part 5, and this is amending paragraph 5B, so part 5 is important to understand. Part 5 is really direction to the court. It is saying, upon receipt of that motion from the defendant that has pled all of the things before that based on that motion, because they're pleading their case and why, that if the prosecution opposes, then they will present why they're opposing. If they raise any issue of material fact, the court will have a hearing. So then, let's assume they don't. The first part of this amendment amends section B. And instead of saying unless the prosecution proves, it says unless the defendant proves by a preponderance of the evidence that the defendant will not suffer an adverse immigration consequence, or that the guilty plea was constitutionally entered. So that would be asking the defendant to stand up there and argue against their own motion, which doesn't happen. That's why you can't change that one word. On C, that's a whole nother area. C, which they're changing in this amendment in the second part, that's after there is a hearing requested or demanded by the court. So in that hearing, well, that's okay. I still want to tell them what's wrong with this amendment.
Madam Speaker Pro Tem, sorry, go ahead.
In that one, the hearing happens, and it says it won't be authorized just based on the documents presented by the prosecution. Because if the person never saw it, if they never initialed on that, or if it was only in English and they didn't speak English, there's lots of reasons to show something was unconstitutional. So that impacts two different processes, and it doesn't work to change that word. So I would urge a no vote.
Is there any further discussion on Amendment L6? Representative Carver.
Thank you, Madam Chair. I think this has been a good discussion, and we appreciate bringing this issue to light. I guess the only thing I would say is, and I know that Rep. Tipper did make it clear that CDAC was neutral, not in a support position. And so, with that, I will withdraw the amendment.
Amendment has been withdrawn. Any further discussion on Senate Bill 103? Seeing none, the question before us is the passage of Senate Bill 103. All those in favor say aye. Aye. All those opposed, no. No. Senate Bill 103 passes. Mr. Shebo, please read the title of House Bill 1133.
House Bill 1133 by Representatives Gray and Caraveo, also Senator Winter, concerning an advance payment of premiums for state employee family and medical leave insurance coverage from the general fund to the Family and Medical Leave Insurance Fund for use by the Division of Family and Medical Leave Insurance to implement services prescribed under the Paid Family and Medical Leave Insurance Act.
Nice, Mr. Shebo. Representative Caraveo.
Thank you, Madam Chair, and very good job, Mr. Shebo. I move House Bill 1133 and the Appropriations Committee report.
To the Appropriations Committee report. We're getting joined by your co-sponsor here, Representative Gray.
Thank you, Senator Gonzalez. In the Appropriations Committee, the funding source from this was changed from the general fund to the Revenue Loss Restoration Cash Fund, and I'd ask for an aye vote.
Any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All those opposed, no. The Appropriation Committee report passes. To the bill, Representative Gray.
Thank you, Madam Chair. I would move Amendment L002 and ask it be displayed.
That is a proper motion. We are waiting for it to be displayed. It is now before us. Please continue, Representative Gray.
Thank you, Madam Chair. Under this bill, and you'll hear more about it in a second, the state would prepay the premiums for paid family and medical leave that the voters approved in Proposition 118. Under the bill, the state would receive interest on the money that it prepaid, so that it would receive a credit for the fact that it paid this money earlier than it was required. And this clarifies the rate upon which that credit would accrue. And I'd ask for an aye vote.
Any further discussion on Amendment L2? Seeing none, the question before us is the adoption of Amendment L2. All those in favor say aye.
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 All those opposed, no. Amendment L2 is adopted. To the bill, Representative Caraveo.
Thank you, Madam Chair. So as you all will recall, the Paid Family and Medical Insurance Program was created after voters across the state and from all political parties overwhelmingly passed Proposition 118, making us the 9th state to implement such a program. And it will provide 12 weeks of paid family and medical leave for people to care for themselves and their loved ones starting in 2024. HB 1133 is simply the way to implement the financing for this program that voters approved in 2020 and the ways that Representative Gray briefly alluded to, basically by allocating $57 million as a prepayment of employer premiums from the state to the family division. And I will pass it over to you.
Representative Gray.
Thank you, Madam Chair. Basically what Representative Carrillo said. This program is going to get up and running, and it's going to get up and running just as the voters intended. The state has the funds to do this right now, and it also gives seed money to the program so that they can hire the vendors and get the IT set up and the things that they need to make this a really smooth transition for both employers and employees. So the last thing we want is to have the voters tell us to do something and us as a state not to logistically follow through on it. And so this does both things at the same time and is a really good bill, and that's for yes vote.
Seeing no further discussion on House Bill 1133, Representative Van Winkle.
Thank you, Madam Chair. And I actually missed the committee hearing on this specific bill, so my apologies. But am I reading it correctly? That's $57 million of general fund? Is that still accurate?
Representative Gray.
Thank you, Madam Chair. No, let me get the name of the fund. Yeah. Based on the Appropriations Committee report from this morning, it's not the general fund, it's from the revenue, it's a cash fund that is a revenue loss and restoration cash fund, but it's not the general fund anymore.
Any further discussion on House Bill 1133, Representative Van Bibber?
Thank you, Madam Chair. I heard this bill in committee, and the aspects of this that I would urge a no vote on are the following. When we heard testimony, we heard that the state does not have a proper process for this to occur in the first place. Thus, this is what precipitated the bill. This is an executive overreach from the executive branch, and so this bill, in essence, is kind of a Band-Aid fix in order to make this happen. The intent of the actual ballot initiative, if you will, would be Paid Family and Medical Leave Insurance Act for all folks who are involved in that particular, who will be using that particular act. What this bill does not do is include all people as per the reason this was passed in the first place. This bill is just for state employees this year. So it excludes everyone else that would be able to benefit from this and under the normal circumstances, which this is not. So for that reason, I urge a no vote.
Representative Gray.
Thank you, Madam Chair. That's a bill that's coming. And I will admit very personally, and people have seen me do it in a committee, that I have confused the various bills I'm working on in this area, but this is not paid family leave for state workers. There is a bill that is going to come that would provide paid family leave for state workers earlier than required by Proposition 118. But that's not this bill. This bill is prepaying the amounts that the state would owe once everybody else is also in the program at the same time. It's just paying the amounts ahead of time. But this is not providing a benefit that's any different than, or any cost that's any different than folks in the private sector or other governments. That bill's coming, but that's just not this one. This one is just a prepayment of when everybody is under the same system the voters approved in 118.
Any further discussion on House Bill 1133? Seeing none, the question before us is the passage of House Bill 1133. All those in favor say aye. Aye. All those opposed, no. House Bill 1133 passes. Mr. Schiebel, please read the title of House Bill 1212.
House Bill 1212 by Representatives Ortiz and Williams concerning the continuation of the regulation of conveyances and in connection therewith implementing the recommendations contained in the 2021 Sunset Report by the Department of Regulatory Agencies.
Representative Ortiz.
Madam Chair, I move House Bill 221212 and the committee reports.
The Public and Behavioral Health Committee report has to the Public and Behavioral Health Committee report. Representative Ortiz.
Thank you, Madam Chair. Members, we did add an amendment in PVH&I, as I like to call it. What we did and what we decided to do was, instead of having to make the department beg to continue to funding their inspectors from the general fund, we decided to allow any of the fines and fees to stay with them. We're not talking about something that just moves materials. We're talking about something that moves people. And so safety is an issue. We want to make sure they're not having to beg, borrow for funding when it comes to making sure that our conveyances are safe. And not only that, we're talking about devices that are some people's basic accessibility. So for that reason, we decided to make sure that they didn't have to ask from the general fund, that they could just keep the fees and the fines.
Any further discussion on the Public and Behavioral Health Committee report? Seeing none, the question before us is the adoption of the Public and Behavioral Health Committee report. All those in favor say aye.
Aye.
All those opposed, no. No. The committee report passes. To the bill, Representative Williams.
Thank you, Madam Chair. My co-prime here pretty much laid the groundwork for what we're discussing. It's a fairly simple sunset review bill. And then we have the report here if anyone's interested, but there are thousands of conveyances that are in operation that need to be inspected for safety reasons. And if you're not sure what a conveyance is, they include elevators, escalators, moving walks, dumb waiters, platform lifts, and automated people movers, such as the movers that you would see at DIA. We have this regulatory framework in place for safety so that people can have assurances that these conveyances are operating safely and properly. Without this, there could be situations where one of these conveyances could be in operation but not working properly. So if you ever get stuck in an elevator, or if, God forbid, something happens with an escalator, we want to try and prevent those types of situations, and that's why we need to pass this bill and allow for the inspections to continue on. So I would ask for a yes vote.
Any further discussion on House Bill 1212? Seeing none, the question before us is the adoption of House Bill 1212. All those in favor say aye.
Aye. Aye.
All those opposed, no. No. House Bill 1212 passes. Mr. Shebel, please read the title of House Bill 1232.
House Bill 1232 by Representatives Valdez and Titone concerning the continuation of the regulation of persons in connection with the control of asbestos and in connection therewith, implementing the recommendations of the Department of Regulatory Agencies contained in the 2021 Sunset Report.
Thank you, Mr. Shebel. I see Representative Valdez on the wall, and perhaps Representative Titone will be joining us soon, but we'll start with Representative Valdez A.
Thank you, Madam Chair. It's an honor to serve with you.
Honor to serve with you.
So this is the Sunset Act that renews the regulation of asbestos for situations where there is a building that has asbestos to be either remodeled or torn down. This is a very important thing. As we know, asbestos contributes to mesothelioma, which is a very serious form of lung cancer. Thankfully, my co-prime today has not brought any asbestos with her, but she showed us kind of how the mineral worked. It's very important that we continue the regulation of the removal of asbestos because in its friable form, it is so dangerous. And what this does is continues that. So I would ask for an aye vote.
And Representative Valdez A, would you like to move the bill?
Yeah, I move House Bill 1232.
Are you sure? I'm just kidding. Representative Titone.
Thank you, Madam Chair. And asbestos has been around a long time. It was a really useful mineral. It's actually a mineral. It's mined in places around the world. And we found out that it's not as good as it is for our health. It's a great thing for strength and heat resistance, but for our health, it's not very good. So this program is to make sure that we have regulation in place to be sure that the health and safety of the people of Colorado is ensured when we're removing these products from buildings and wherever else we might find them. So I think this is something we really need to continue. So I urge an aye vote on the bill.
Is there any further discussion? Representative Pico.
Thank you, Madam Chair. I rise in somewhat reluctant opposition to the bill. I would first off say I'm absolutely in favor of regulation of asbestos. Where we have a little bit of an issue is that it removes the limits on the ability of the Air Quality Control Commission to promulgate rules more stringent than the standards set forth in the Federal Occupational Safety and Health Act and federal regulations promulgated pursuant to that. That's kind of the heartburn I have with this, in that it just opens the door to anything with no restraint. OSHA does use science-based applications in the generation of the rules, and that's the point of my opposition. I don't oppose the sunset. I do oppose removing that.
Any further discussion on House Bill 1232? Seeing none, the question before us is the passage of House Bill 1232. All those in favor say aye. All those opposed, no. House Bill 1232 passes. Mr. Shebel, please read the title of House Bill 1249.
House Bill 1249 by Representatives Burnett and Hooton, also Senator Rankin, concerning the creation of a roadmap for improving electric grids in the state.
Well, we have on this bill Representative Hooton and Representative Burnett. Make your way down the green carpet. Strike a pose. There you go. Representative Hooton.
Thank you, Madam Chair. Thank you, members. I move House Bill 1249 with the Energy Committee report and Amendment L.
And the Appropriations Committee report.
And the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. Madam Chair, the committee report adopted the amendments that were accepted in the Energy and Environment Committee.
Oops. Any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye. All those opposed, no. Appropriations Committee report passes. To the Energy and Environment Committee report. Representative Hooton. Representative
Thank you,
Hooton.
Madam Chair. I move amendments L01, L001, L002, and L003.
Okay. Let's do one amendment at a time, and these are to the committee report, correct?
Yes, ma'am.
Okay, so why don't we start with L001 if you want to move that and ask for it to be displayed.
Thank you. Madam Chair, I move L001 and request that it be displayed.
We're going to take a brief recess. Okay.
we amend the committee report.
Yes, this right here.
Okay.
The House will come back to, the House will come back, I'm sorry, the committee will come back to order. Representative Hooton.
Thank you, Madam Chair. I move to amend the committee report.
And you have an amendment that you would like to move to the committee report?
Yes, I move Amendment L005 and ask that it be displayed.
That is a proper motion. And we'll wait just a moment until it's before us.
Go ahead, raise your hand.
Okay.
It is properly displayed. Representative Burnett, please proceed.
Thank you, Madam Chair. This just includes the representatives of the Division of the Fire and Prevention Control section as part of the stakeholder. And we're changing a word customer choice to customer options, as well as adding some language that gets labor to a neutral position. And I ask for an aye vote.
Any further discussion on Amendment L5? Seeing none, the question before us is the adoption of L5 to the Energy and Environment Committee report. All those in favor say aye.
Aye.
All those opposed, no. L5 has been adopted.
Go ahead.
Representative Hooton.
Thank you, Madam Chair. I move the committee report.
As amended.
As amended.
Okay, any further discussion on the committee report? Seeing none, the question before us is the adoption of the Energy and Environment Committee report as amended. All those in favor say aye.
Aye.
All those opposed, no. The committee report is adopted. To the bill,
Okay, so
Now you go.
okay.
Representative Burnett.
Thank you, Madam Chair. Okay, in committee, we added a draft roadmap for public comment by July 2024. We also added a number of stakeholders and also considered utility wildfire mitigation plans, as well as some words to help harden the grid for both individual customers and in circumstances where extending the distribution grid may not be practical. We also added words about distributed energy resource planning and public-private partnerships, and basically some cleanup from there.
Any further discussion on House Bill 1249? Seeing, okay, Representative Van Beber.
Is it done?
Thank you, Madam Chair. While I did not hear about this bill in committee, let me start with thanking the bill sponsors for bringing a bill forward that probably speaks to one of the most concerning and pressing issues that all 6 million Coloradans will face on any given day. When we speak about resiliency and reliability on the energy load in the state of Colorado, we speak to the very real fact that without electricity, without the major fundamental pillars that would keep a society going, Colorado will need to continue to look to solutions that will protect our energy, our electricity, the electrons flowing through our lines, water, sanitation, communications, and transport. And so when we look at the idea of a grid down event or man-made or all grid down events that can be occurred through weather-related issues as well as man-made issues, I have an appreciation for the bill and what the sponsors bring forward in trying to create or looking at the possibility of creating pockets of energy that may be possible in certain areas around the state of Colorado. What greatly concerns me, though, is that the energy that we take for granted here in the state of Colorado, in addition to communications, water, transportation, is that in a grid down event, the first thing I would like to make clear is that it is complicated. And as a complicated issue, we speak to the factors of software, we speak to the factors of hardware, we speak to the factors of actual physical equipment, what we call the architectural engineering of our electrical grid. Now, where we sit right now is not in compliance with SB 21072. And in that Senate bill, it requires the state of Colorado to ensure that using the roadmap that we do have for emergency energy preparedness, Colorado falls short of that. What concerns me is this bill does not in any way address falling into compliance with that particular Senate bill. Speaking to the topic of protecting the grid here in the state of Colorado, which could be under attack and has been under attack at any given moment, this bill falls short of all of the things that I've just mentioned, whether pockets of energy going out or, even worse, cascading events that cause us to have 90 to 100% blackout here in the state of Colorado. This results in the most devastating of outcomes that I come to this well and don't really want to talk about because it is such a dark and concerning outcome. It involves millions of deaths. Now, while a microgrid might be able to harden a spot in a very small place, and the intent of this bill is to explore that energy, I would like to share what the National Renewable Energy Lab right here in Colorado has to say about doing things such as this with microgrids. Straight from the National Renewable Energy Lab, they state, transitioning to a grid with a more inverter-based resource poses major challenges because the operation of future power systems must be based on a combination of the physical properties and control responses of traditional large synchronous generators, as well as those numerous and diverse inverter-based resources. These challenges stem from the recognition that there is no established body of experience for operating hybrid power systems. What you see before you today would in fact create hybrid power systems. Those hybrid power systems would represent significant amounts of inverter-based resources at the scale of today's North American interconnections. Although the focus of this roadmap is an inverter-based generation, so storage in batteries, storage in places where we might have a small amount of energy for a very small amount of time, the details of grid-forming storage applications such as charging, discharging, and state of charge are well beyond the state of this roadmap. We have work to do. The bill sponsors are absolutely correct in that this is an applicable an important need. But supporting this roadmap is not the place to start. It does not have the right processes in place. It does not help us fall into alignment with Senate Bill 21072. And it certainly doesn't speak to the complicated, necessary things that should be in place to ensure that we are protected from grid down events, be they nuclear, non-nuclear, man-made, weather-related, or more. So these are just some of the reasons that I bring in opposition to this bill forward. The solutions are in play. Colorado has been presented with them. And I, again, urge a no vote on this bill for this and many more reasons that we'll continue to discuss, I'm sure.
Any further discussion on House Bill 1249, Representative Pico?
Thank you, Madam Chair. I rise in opposition to the bill. There's an awful lot in this bill which is really, really good, and I want to say that up front. I support the idea of microgrids. I have operated within microgrids. I've operated inside of EMP-hardened microgrids. There's a lot of technical issues to do with that, and the concerns I have with the bill is that it makes a number of assumptions and drives it in a specific direction. It targets the idea that you're going to reduce emissions. Well, a microgrid in reality is not going to work unless you've got something to back it up, and that's what's a big part of what's missing in this bill. We already have microgrids all over the place, and there really is not a need to send a state-mandated plan to proliferate microgrids. For one thing, as I said, microgrids already exist in every critical facility that has a need to maintain a power. That is, by definition, a microgrid. If your hospital has got a backup generator, if the police department has a backup generator, that's a microgrid. And they're able to operate in absence of the rest of the grid. What a microgrid in a larger area will do is spread that reliability. It can take a particular area off the grid that actually degrades the grid's ability to sustain itself, resist downtime, and it negatively impacts the ability of the grid to recover from an outage if you have too many of these. there are a place for microgrids. They really need to be there. But the idea, for example, that you're going to reduce emissions, as I've said, doesn't work. If you have a microgrid, you have to have that power backed up. And we heard in testimony of 1 or 2 places that have enough batteries and a small enough area that they serve that they think that they can survive for a while. But in the vast majority of cases, that isn't the case. In order to maintain power within a microgrid, you've got to have a backup generator, as I've said, and almost every backup generator is going to burn something to get there, whether that be natural gas, whether it be coal, whether it be anything else. Unless you start proliferating small modular nuclear reactors, you are not going to have microgrids that don't add to the emission load. That is engineering. That's basic physics. So while I applaud the idea, what's behind here, but I agree with the intent and where they want to go, I don't think this bill covers it at the point. I think there needs to be a little bit more effort on what's already in place, and I ask for a no vote.
Any further discussion on House Bill 1249? Representative Will.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, sir.
And like my colleague just said, I mean, if you look at the title of the bill and all that, it sounds good, and it sounded good. And then we listened to it in committee, and had some problems with it there. And I was a no vote in committee. We heard from a Mr. Spence from the task force on National and Homeland Security. We also heard from a Mr. Rhodes, that's the director of those operations in Homeland Security, and they both said this is not prime time ready. This bill is not prime time ready. Do we need to do this? Yes, we do. But this bill it's just not ready to go. They said we're probably at least 2 years out. There's a lot more discussions and conversations that need to go on. Sure, grid reliability, we all want that. It's important, it's critical. And then when you start looking at it on a global scale, I looked at the task force that worked on this from Homeland Security, and I want to make a few statements about the summary of that study. But it said, while the threats of global climate change and now COVID-19 pandemic have received worldwide attention, the hazardous effects of EMP's attack have received much less consideration. Awareness of their potential and risks remained low even among top U.S. policymakers. However, the EMP threat encompasses both naturally occurring threats, geomagnetic storms stemming from solar coronal mass injections, and man-made threats, EMP attacks by a foreign adversary, and may well pose an even more deadly and devastating threat to America, our environment, and the world. And so for decades, scientists have warned us about this, and it's overdue. This kind of grid resiliency is overdue. After listening to those two people testify in committee, I was a strong no, and I remain a strong no on this. I applaud the bill sponsors for bringing this forward, because it is. I mean, this is what we need to do, but we need to have way more discussions on this. And like I say, the experts say we're probably at least 2 years out to come up with something that would work for Colorado and, of course, the nation. We're talking only about Colorado here, but so I'll remain a no on this bill. Even though I do applaud the efforts of the bill sponsors, because I think we need to be moving in this direction. I just say this isn't prime time ready at this point in time. Thank you.
Any further discussion on House Bill 1249? Representative Van Bibber.
Thank you, Madam Chair. When we think about something as broad and as deep, and very seldom does a topic come to this chamber that affects each and every one of us in the most critical way that this particular topic does, the bill sponsors actually state Colorado lacks a comprehensive strategic plan that both identifies and prioritizes these critical facilities of vulnerable communities and makes recommendations on how to improve grid resilience and reliability. When I think of that statement and the intent and the motivation as to why you would do that, you have my utmost support. When it comes to using this process to do so and commingling air quality as a part of that, I am deeply, deeply, deeply concerned that issues that have to do with air quality are commingled with protecting the electrical grid that we need to survive as a society in the state of Colorado. The scope of what needs to be done here is possible. The processes that this begins to touch on are absolutely appropriate. Bringing in all of the right and necessary entities to ensure that this is done to fruition in a way that best benefits us all without burdening the state of Colorado and the taxpayers in a way where we throw good money after bad is not present. I urge a no vote on this bill. Thank you for bringing this forward, but I cannot emphasize enough how deeply concerned I am that we would start here rather than in a place where we would absolutely be assured of protecting the grid across the state of Colorado, rather than creating pockets of concerns all across this state that would actually worsen the problem that the bill intends to solve. So with the greatest respect, I do urge a no vote.
Seeing no further discussion, Representative Hooton. You can both go up there. Representative Hooton.
Thank you, Madam Chair, and thanks for the dialogue. Just a couple of comments for the members. Representative Will did raise a concern about the timeline, and I would just like to remind the representative and our members that the Colorado Energy Office has until 2025 to issue a report to the legislature. And so we feel that's an adequate amount of time to make a recommendation. And the second point I'd like to make is that there are multiple things that we are attempting to address in the roadmap. One of them is the big grid resiliency, and the other are standalone microgrids who don't play a role in resiliency of the big grid, and non-wire alternatives that are primarily behind the meter and are personal appliances that could be used to generate energy in a home or in a business. So while I appreciate the reflections of Representative Van Beber, I would just want to remind everyone that the bill is not entirely about grid resiliency, but it does address the multiple ways in which microgrids might be used. Thank you.
Any further discussion? Representative Burnett.
Thank you, Madam Chair. I also want to emphasize that this bill has extensive stakeholding. This is why it's taking so long. It's taking to January 2025 for this bill, for the recommendations of this roadmap to do this. This is the microgrid developers, the Public Utilities Commission, Office of Consumer Advocacy, utilities, labor, disproportionately impacted communities, communities at risk for outages, municipalities and local governments, then the whole wildfire department of public safety, homeland security, emergency management. All these people are involved in the stakeholding. And so this whole bill is to figure out whether and how microgrids can protect our critical facilities and reduce the impacts of power outages. And so it also is looking at providing different examples on how these microgrids can be deployed and what types of critical facilities and communities who are at high risk for power outages are involved in this. And it's developing recommendations for future legislation and regulatory actions, including the definition of a microgrid and key factors to consider: legal, regulatory, economic, and other barriers that we have, financial and technical support, and education and outreach programs. This bill does not restrict any development of microgrids that are going on currently planned right now, but we want to learn from those experiences, and that stakeholding takes time. So this bill is developer agnostic, it's technology agnostic, and I urge, it's a very thoughtful, comprehensive approach that optimizes in an efficient and cost-effective and safe deployment of microgrids, and I urge a yes vote on House Bill 1249 as amended.
Representative Pico.
Thank you, Madam Chair. It probably doesn't come as a shocking revelation to anybody as we talk about electrical generation, but I have concerns with what was just said. This is the bill is not agnostic. It is very heavily biased towards solar, wind, and batteries. And it's very clear in how it's laid out. And that is my concern, is that it is not agnostic. It is talking about pushing a particular set of solutions. Microgrids are already being deployed. They're already in place. They have been in place for decades. We already have many of these things without the need of having a state roadmap. Different utilities are putting those in place. The utility that I helped run for a while, we've had microgrids in place, and we're fielding more. This is not something we need the state to tell us how to do. And that's part of my concern, is what the roadmap is going to do is tell us how we should do that. We know how to do that. That's an engineering issue. But these, as presented, is not going to assist in hardening the reliability of the grid, because you're going to disperse the assets all over the place and come up with different ways, but focused on using batteries as the backup. And batteries by themselves simply won't work. The non-wire alternatives are in reality wires. They're just going into individual homes or businesses and using batteries. You're going to have to develop an awful lot of battery capacity, and we've got a couple of studies out that say you will never be able to build enough batteries fast enough to meet what people think they are going to need to make this thing work. We do need to have a lot of studies. We do need to have microgrids to help protect certain critical areas. We do need to have a lot of that. We don't need the state to tell us how to do that. The utilities are already doing that. They're already working that. And different communities are already working that. So I urge a no vote, and let's take this back and work at it a little bit more.
Representative Van Bipper.
Thank you, Madam Chair. While the bill sponsor speaks to the concept of resiliency on the grid, the other issue that we have to pay attention to is the reliability. And the reliability wraps itself around the need to ensure that the different kinds of components that I had mentioned earlier, software, physical hardware, the architectural engineering, and the things that need to be in place to be protected from man-made or weather-related events are in place. A roadmap does not do these things. We are looking at the start of a 1% solution to a 99% problem, where we do not address the macro pieces to our Colorado infrastructure that would need to be protected in grid down events. The kind of thing that we are looking at today, the roadmap that we are looking at today, as Representative Pico just said, is that we already know how to create microgrids. We already know how to have energy storage. That in and of itself will never do what the real problem needs to have done, and that is to protect the Colorado grid in the event of grid down events. Within the last 2 years, the transformers just 2 miles north of my home by Sandia Labs were discovered to have Chinese hardware on them that could be accessed remotely. This is public information. This roadmap does not solve that. Within the last 18 months, the meatpacking plant in Weld County, JBS Meats, was ransomwared for over $18 million. This bill does not protect us against that. Within the last 5 to 10 years, Portions of Colorado, and actually within the last 18 months, portions of Colorado have been without electricity for 4 days because of blizzards, my home being one of them. This bill does not protect us from that. There are starting places with which we should begin to protect the grid, to create the reliability and the resiliency that you see before you today as the focus to protecting lives. However, this bill does not do what we need to do to save lives. When we want to protect our hospitals, when we want to protect our water, when we want to protect critical communications in the event that we are attacked or that we lose electricity, this bill does none of those things. So again, I urge a no vote. Those are my thoughts and responses to the things that have been brought up today. Whether we spend 1 penny or $100,000 as the fiscal note states, please do not throw good money after bad. I urge a no vote.
Representative Burnett.
Thank you, Madam Chair. I would like to move House Bill 1249 L004 amendment and ask that it be displayed.
Okay, so you are moving Amendment L4 to House Bill 1249.
I move Amendment L4 to the
To House Bill
House
1249.
Bill 1249
And ask
that
for
it be displayed.
Thank you. It is before us. Please continue. Representative Burnett.
Thank you, Madam Chair. What this does is it adds that the microgrid roadmap consider electromagnetic interference caused by electromagnetic pulses.
Any further discussion on Amendment L4? Representative Pico.
Well, I certainly don't oppose the amendment, but I think that was already in the bill because it talked about resiliency. I have operated EMP hardened facilities, and I have operated, been through that EMP training to a level that I can't really discuss here. The amendment, it's fine. You include that. That's part of it. But I don't think the bill itself comes anywhere close, even with this amendment, to addressing what this amendment is trying to bring up. So I support the amendment, but I'm still a no on the bill.
Representative Holtorf.
Thank you, Madam Chair. I really like this amendment, and I'm going to tell the body why. Now more than ever, in light of the war in Ukraine, in light of Russian threats of using nuclear weapons to meet their war aims and goals, in light of the nuclear armament systems that are out there, and most concerning to me is the fact that the Russian military actually went through nuclear drills at the start of the war against Ukraine actively, which our national security assets actually tracked, that they really did it. They just weren't saying they did it. This right here complements building the defenses we need if something like that were to happen. Right now, I think we need leadership in this space. I think we need leadership in talking about how we protect ourselves from these dangers. I don't want to be an alarmist, but I do think that this is a very important amendment, and I do support it, adding this to the corpus of the bill.
Any further discussion on Amendment L4? Seeing none, the question before us is the adoption of Amendment L4. All those in favor say aye. Aye. All those opposed, no. Amendment L4 is passed. Representative Pico.
Thank you, Madam Chair. Now we've added EMP to the bill. Here's my concerns with that. EMP is a very hard and technical issue. The vulnerabilities are huge across the grid. A microgrid that is hardened is going to involve an awful lot of technical issues that our current energy office has no real way to address. I've been involved in that. I've been involved in defending against EMPs, and without going too much detail, I've been involved in the planning to apply that to other people. But we are in a particular threat period, as just alluded to. We do have that threat. That threat has been against us for quite a long time from a number of different countries, a number of different sources, and natural, because electromagnetic pulse, while strictly defined as being a man-made event, the same effect can become from natural. And we are, in fact, experiencing a electromagnetic storm today as we speak. And oddly enough, our grid is surviving that. Why? Because it has been engineered already. How much more do we need is something that the utilities are all responsible for doing and have been doing and are doing. Microgrids, as they proliferate, in reality will just open up new avenues of attack for those who want to get into our systems. So for those reasons, I still urge a no vote on the bill.
Representative Van Bibber.
Thank you, Madam Chair. Now that we've added the critical issues of cybersecurity, EMP, the software and the hardware piece, even more, I would refer to the fact that when stakeholdering came up and the right stakeholders were mentioned, most of those were departments within the state of Colorado. And I would absolutely say with certainty, knowing who testified and who stakeholdered in this process, because of this amendment, we absolutely do not and have not had the right stakeholders in this conversation to ensure that this bill meets the amendment and anything else that it would like to accomplish. We absolutely do not have the right stakeholders in place. This is something that affects us at the local level, the state level, and the federal level. Our communications are complex, and the electrons flow through all three spaces. And to not have all of those entities in play in discussion on this topic is certainly far, far below what we would want to hope would be the right solution for what the bill sponsors would like to have done. So again, I urge a no vote on those for those reasons.
Seeing no further discussion, Representative Holtorf.
Thank you, Madam Chair. I believe in the bill, as I read the bill summary, there is going to be the departments traveling around the state. They are going to do more public hearings. They are going to do some things that are going to elevate the conversation. Trying to think the best way to say this as not to offend. In my humble opinion, we are so far behind in technical infrastructure development in this country. If we want the United States of America to survive into the 22nd century, I will tell you, the threats are not going to go away. The challenges are only going to get more difficult for our republic. And we have to take technology to the next level, just as we take our space travel technology to the next level. This is what makes America the hegemon of the world. And I am proud to say this. I challenge anyone to debate me on why that is necessary. We have to keep our technological advantage. We have to build these things to a level that has never been built in the world to survive, even in the most extreme situations. Now, I'm a big supporter of microeconomies. You may have heard me give the speech, and I'm not going to give it again, about how we have torn down our microeconomies, and particularly in agriculture, and now we have these big economies and these big growing overarching growth and monopolization of things. But the more micro grids we have, the more electric cooperatives we have, the more technology we build to harden these things against even solar flares and other type more intense attacks, electromagnetic attacks, maybe even nuclear attacks. Imagine if we do this and we build this technology, and in 20 years, our grid is so hardened that even the Chinese, as they try to flex their muscles, cannot threaten us. Or any other nation, for that matter, that wants to replace us as the world hegemon. Now, I don't want to get too philosophical here, but I tell you, this is a direction that is needed, I believe, both micro and macro. That the amendment is so important because people don't talk about this.
Representative
talk about
Holtorf,
it.
we
Yes,
are
ma'am.
we are on the bill right now, so I just want to make sure we adopted the amendment.
No, I understand that, but I'm tying the amendment back to the bill and how important the bill is, ma'am. But I do appreciate your leadership and your guidance. So I'm going to yield this conversation, but I think this is important stuff.
Thank you. Seeing no further discussion on House Bill 1249, all those in favor of the passage of House Bill 1249, please say aye. All those opposed, please say no. House Bill 1249 passes. Mr. Schiebel, please read the title of House Bill 1261.
House Bill 1261 by Representatives Roberts and Ricks, also Senators Hansen and Priola, concerning the continuation of the Board of Real Estate Appraisers and in connection therewith implementing the recommendations contained in the 2021 Sunset Report by the Department of Regulatory Agencies regarding the Board of Real Estate Appraisers.
Representative Ricks.
Thank you, Madam Chair. I move House Bill 1261, the Committee Report of Appropriations and the Business Report.
There's only the Business Affairs and Labor Report, no Appropriations Committee report. So to the Business Affairs and Labor Committee report.
Thank you, Madam Chair. So in business, the bill passed, and we did an amendment making sure that the funds were going to go back to the Board of Real Estate instead of to the general fund. And that was an amendment that we did.
Is there any further discussion on the Business Affairs and Labor Report? Seeing none, the question before us is the adoption of the Business Affairs and Labor Committee report. All those in favor say aye. Aye. All those opposed, no. No. The committee report passes. To the bill.
Thank you. So this is a sunset
Representative
bill.
Ricks. Sorry.
Thank you, Madam Chair. This is a sunset bill, and it's around from the Board of Real Estate Appraisers. This bill is going to continue the board until September 1st, 2031. It's also requiring the board to adopt rules to allow for an appraisal to provide evaluations to a financial institution when the appraisal is not required. It's going to bring our state statutes in conformity with federal laws. It's clarifying the fines that are assessed per violation cannot exceed $1,000. And it's also repealing the requirement to send letters of admonition by certified mail. So it's a great bill. Real estate appraisals are very important to our real estate market, and we need them, and we also need to regulate them. So we ask for an aye vote.
Any further discussion on House Bill 1261? Seeing none, the question before us is the passage of House Bill 1261. All those in favor say aye. Aye. All those opposed, no. House Bill 1261 passes. Mr. Schiebel, please read the title of House Bill 1265.
House Bill 1265 by Representative Exum concerning the continuation of the Education Data Advisory Committee and in connection therewith implementing the recommendations contained in the 2021 Sunset Report by the Department of Regulatory Agencies.
Representative Exum.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, sir.
I move House Bill 1265 and the Education Committee report.
To the Education Committee report. Representative Kipp.
Thank you, Madam Chair. The Education Committee report, we actually put on an amendment that was agreed upon by the Colorado Department of Education and the Education Data Advisory Committee, just so that we could make sure that we could resolve any differences in opinion between those two groups.
Any further discussion on the Education Committee report? Seeing none, the question before us is the adoption of the Education Committee report. All those in favor say aye. All those opposed, no. Education Committee report is adopted. To the bill, Representative Exum.
Thank you, Madam Chair. The EDAC was created to examine the effects of data collection on Colorado kindergarten through 12th grade public education. Data collection by CDE and other agencies at every level of government are scrutinized by EDAC to determine the costs versus benefits derived from individual mandates. The EDAC then suggests the most effectual ways of collecting the data, concludes if new proposed collections are necessary and may propose alternatives, and recommends the process to improve the CDE. And that's what was done with the amendment, and we ask for an aye vote on this sunset bill. Thank you, Madam Chair.
Any further discussion on House Bill 1265? Seeing none, the question before us is the passage of House Bill 1265. All those in favor say aye. Aye. All those opposed, no. House Bill 1265 passes. Mr. Shebel, please read the title of Senate Bill 32.
Senate Bill 32 by Senators Bridges and Woodward, also Representatives Kipp and Van Winkle, concerning simplification of local sales and use tax compliance and administration for retailers that make retail sales in local taxing jurisdictions where they have limited physical presence and in connection therewith making an appropriation.
Representative Van Winkle.
Thank you, Madam Chair. I move House Bill Senate Bill 32. And there's no committee report.
To the bill. Representative Kipp.
Thank you, Madam Chair. So this is a bill that came out of the Sales and Use Tax Simplification Task Force. This is the third of 3 bills. We've already brought you the other 2. This is probably the one that's going to have the most impact on our business community. Basically, as we've said before, Colorado has an extremely complicated sales and use tax system for our local businesses. And this one is to help businesses when they have just a incidental physical or limited physical presence in an area, not dealing with the business licenses in that case. We're going to say that business licenses cannot be charged for by that local jurisdiction.
Representative Van Winkle.
Thank you, Madam Chair. Yeah, this is a very good bill that will be very helpful to the hardworking taxpayers and job creators of Colorado. They just want to pay their taxes they're required to pay without having to jump through so many hoops. And right now they're faced with sometimes getting multiple, actually dozens and dozens of businesses licenses in dozens of jurisdictions across the state of Colorado simply for the right to pay their taxes. So for example, if you run a t-shirt company or something out of your garage and you're shipping those t-shirts statewide, for every place that you ship a t-shirt, then you have to, for the right and privilege of paying your taxes, you have to often pick up a business license in that jurisdiction. So businesses go city by city and jurisdiction by jurisdiction to pick up that license, and then they have to keep track of when they're up for renewal. And oftentimes, if even one of those is missed, then that business is out of compliance with our tax law. So what this bill does is it simply makes it dramatically easier for those businesses and keeps them from having to get so many and pay fees on top of it for each business license in each jurisdiction. So a very good bill. It's brought to us by the small businesses and hardworking taxpayers of Colorado, and I urge a yes vote.
Any further discussion on Senate Bill 32? Seeing none, the question before us is the passage of Senate Bill 32 for the hardworking people of Colorado. All those in favor say aye. Aye. All those opposed, no. Senate Bill 32 passes. Madam Majority Leader.
Thank you, Madam Assistant Majority Leader Chair. I move the committee rise and report.
You have heard the motion. Seeing no objection, the committee will rise and report. Oh, that was fast. Oh.
House will come to order. Mr. Shebel, please read the report of the Committee of the Whole.
Mr. Speaker, your Committee of the Whole begs leave to report has under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1133 is amended 1212, is amended 1232, 1249 is amended 1261, is amended 1265, is amended passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 32, Senate Bill 103 is amended passed on second reading and ordered revised and placed on the calendar for third reading and final passage.
Assistant Majority Leader Gonzalez Gutierrez. As a proper motion, there are no amendments at the desk. Mr. Shebel, please open the barn door. No. Oh, it was withdrawn? All right. Sorry. The motion before us is the adoption of the Committee of the Whole report. Mr. Shebel, please open the machine. For those participating online, Minority Leader McKean.
No.
Minority Leader McKean votes no. Representative Sandridge.
No.
Representative Sandridge votes no. Representative Pelton.
No.
Representative Pelton votes no. Representative A. Valdez.
Yes.
Representative A. Valdez votes yes. Representative Roberts.
Yes.
Representative Roberts votes yes. Representative Michelson Janae.
Yes.
Representative Michelson Janae votes yes. Representative McCluskey.
Yes.
Representative McCluskey votes yes. Representative Hanks, how do you vote?
No.
Representative Hanks votes no. Please close the machine. With 39 aye votes, 23 no votes, and 3 excused, the report of the Committee of the Whole is adopted. That brings us to third reading of bills, final passage. Mr. Shebel, please read the title of the House Bill 1297.
House Bill 1297 by Representatives Kipp and Neville, also Senators Bridges and Scott, concerning the designation of daylight saving time as the standard year-round time within the state when allowed by federal law.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1297 on third reading, final passage.
Question before us is the adoption of House Bill 1297 on third reading and final passage. See no further discussion. Mr. Shebel, please open the barn door. Minority Leader McKean, how do you vote?
Yes.
Minority Leader McKean votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Pelton, how do you vote?
Yes.
Representative Pelton votes yes. Representative A. Valdez, how do you vote?
Yes.
Representative A. Valdez votes yes. Representative Roberts, how do you vote?
Yes.
Representative Roberts votes yes. Representative Michelson Janae, how do you vote?
Yes.
Representative Michelson Janae votes yes. Representative McCluskey, how do you vote?
Yes.
Representative McCluskey votes yes. Representative Hanks, how do you vote?
Yes.
Representative Hanks votes yes. Please close the barn door. With 50 aye votes, 12 no votes, and 3 excused, House Bill 1295 is adopted. Co-sponsors. Representative A. Valdez, co-sponsor. Representative Pelton, co-sponsor. Please close the machine. Mr. Shebel, please read the title of Senate Bill 152.
Senate Bill 152 by Senators Fenberg and Hawkes Lewis, also Representatives Gray and Burnett, concerning authorization for a person whose residence is destroyed or becomes inhabitable to continue to use the address of the residence as the person's residence for purposes of voting if the person intends to return to the residence once it is replaced or becomes habitable.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 152 on third reading, final passage.
The question before us is the adoption of Senate Bill 152 on third reading and final passage. See no further discussion. Mr. Shebel, please open the machine and members, please proceed to vote. Minority Leader McKean, how do you vote?
Yes.
Minority Leader McKean votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Pelton, how do you vote?
Yes.
Representative Pelton votes yes. Representative A. Valdez, how do you vote?
Yes.
Representative A. Valdez votes yes. Representative Roberts, how do you vote?
Yes.
Representative Roberts votes yes. Representative Michelson Janae, how do you vote?
Yes.
Representative Michelson Janae votes yes. Representative McCluskey, how do you vote?
Yes.
Representative McCluskey votes yes. Representative Hanks, how do you vote?
No.
Representative Hanks votes no. Please close the machine. With 61 aye votes, 1 no vote, and 3 excused, Senate Bill 152 is adopted. Co-sponsors. Representative Roberts, Pelton, McCluskey, Michelson Janae, co-sponsor.
Mr. Speaker, I was just pushing the button on my screen.
No
I was
worries.
not a-
Sorry about that. Representative Pelton is not a co-sponsor. All taken care of. Please close the machine. Mr. Shebel, please read the title of House Bill 1307.
House Bill 1307 by Representatives Valdez D and Pico, also Senator Moreno, concerning technical changes to the Practice Acts regulating mental health providers.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1307 on third reading, final passage.
Question before us is the adoption of House Bill 1307 on third reading and final passage. Seeing no further discussion, Mr. Shebel, please open the machine and members please proceed to vote. Minority Leader McKeon, how do you vote?
Yes.
Minority Leader McKeon votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Pelton, how do you vote?
Yes.
Representative Pelton votes yes. Representative A. Valdez, how do you vote?
Yes.
Representative A. Valdez votes yes. Representative Roberts, how do you vote?
Yes.
Representative Roberts votes yes. Representative Michelson Janae, how do you vote?
Yes.
Representative Michelson Janae votes yes. Representative McCluskey, how do you vote?
Yes.
Representative McCluskey votes yes. Representative Hanks, how do you vote?
Yes.
Representative Hanks votes yes.
Yes.
Please close the machine. With 62 aye votes, 0 no votes, and 3 excused, House Bill 1307 is adopted. Co-sponsors. Representative Michelson Janae, co-sponsor. Please close the machine. Mr. Shebel, please read the title of Senate Bill 143.
Senate Bill 143 by Senators Kirkmeyer and Woodward, also Representatives Pico and Lynch, concerning an update to terminology used to refer to the regulatory entity within the Department of Regulatory Agencies that regulates particular healthcare professions.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 143 on third reading, final passage.
Question before us is the adoption of Senate Bill 143 on third reading and final passage. Seeing no further discussion, Mr. Shebel, please open the machine and members please proceed to vote. Minority Leader McKeon, how do you vote?
Yes.
Minority Leader McKeon votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Pelton, how do you vote?
Yes.
Representative Pelton votes yes. Representative A. Valdez, how do you vote?
Yes.
Representative A. Valdez votes yes. Representative Roberts, how do you vote?
Yes.
Representative Roberts votes yes. Representative Michelson Janae, how do you vote?
Yes.
Representative Michelson Janae votes yes. Representative McCluskey, how do you vote?
Yes.
Representative McCluskey votes yes. Representative Hanks, how do you vote?
Yes.
Representative Hanks votes yes. Kalen. Please close the machine. With 60 aye votes, 2 no votes, and 3 excused, Senate Bill 143 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to labor the balance of the calendar until Monday, April 4th.
Seeing no objection, the balance of the calendar will be laid over until Monday, April 4th. That brings us to announcements and introductions. Madam Speaker Pro Tem Benavides.
Thank you, Mr. Speaker. And members, this isn't a tribute, but I'm doing this on behalf of some members in the lobby, is that this is April 1st, and it's the first day of National Donate Life Month. This month is to help raise awareness about donations, encouraging all Americans to register as organ, eye, and tissue donors, and to honor those that have saved lives through the gift of a donation. Donate Life is the symbol of the cause of organ, eye, and tissue donation and transplantation. In a show of support, Governor Polis has officially proclaimed April as Donate Life Month in Colorado. Colorados can sign up to be donors, and just by saying yes when they register to or renew their driver's license or get a state ID. And on September 15th of 2017, the donor registry adopted the Yes Carryover. So if you've done it once, it carries over until you change it. We here in Colorado, we remain one of the most generous states in the country. In fact, we are leading the nation at 67% donor designation rate. Nearly 1 million Coloradans added their names to organ, eye, and tissue donor registry in 2021. And just one donor has the power to save up to 8 lives through organ donation and more than 75 lives through tissue donations. That said, though, there's nearly 1,500 people in our region who are currently waiting for a life-saving transplant in Colorado. So I really encourage you to talk to your family and think about doing it, because everyone, regardless of age or health conditions, can sign up to be a donor. And all major religions support organ, eye, and tissue donation, and many view it as an act of love and generosity, no matter your age or your health. Be someone's hero this year. Say yes to organ, eye, and tissue donation. One heroic choice can save and heal lives of so many. Thank you, members. Representative Neville.
Thank you, Madam Speaker Pro Tem. We have a tribute we requested to be read at length.
Usually we stand.
Do you have it
tributes,
with
but
you?
It's up to you guys. It's cool. It's cool.
You have it? All right.
It's cool.
Members, we're going to hear a tribute. Mr. Shebo.
Okay. State of Colorado. The House of Representatives convened in the 73rd General Assembly hereby sincerely commemorates all tributes.
Tribute to a tribute.
Often thought of as the annoying little brother of resolutions, tributes are a great way to acknowledge the subjectively important dates, places, or occurrences in any representative's lives. Maybe you want to make a month the official month of anything whatsoever, or want to celebrate something like a birthday or a flower festival. Or perhaps your child lost a tooth, or placed 5th in the Pinewood Derby. Whatever it may be that can help you get reelected, rest assured, we can do a tribute for it. Come to the clerks with your tribute desires, and certainly we can find a chance to draft one for you. The best part about tributes is the clerks are great at making stuff up. So all you have to do is give us the tribute title. Then stand up here for a couple of minutes while I, Mr. Scheibel, or Scheibel, read a short, vague paragraph. From early in the morning until late at night, we continue to commemorate, congratulate, and celebrate organizations and people we've never even heard of. Tributes truly are a staple of the Colorado House of Representatives, giving some reps an opportunity to share what may or may not be important to anyone, and giving others a chance to refill their coffee or make it to the floor in time for roll call. As session drags on and we are faced with uncertainty, hopefully we can all find comfort in the daily tribute. The Colorado House of Representatives hereby cancels all future tributes and fines all members who have run a tribute this year, let's say $3.59. The House of Representatives extends heartfelt commendations to each and every tribute to have graced this chamber and sincerely thanks all members who have had tributes read at length. On request of Representatives Patrick Neville and Alec Garnett, given this April Fool's Day 2022, State Capitol, Denver.
Representative Neville.
Thank you, Madam Speaker Pro Tem. And members, this tribute to tributes, I want to tribute that process because honestly, this was just something that I threw out there and the clerks all did a great job in drafting this. So this tribute is an example of how you can even do a tribute to tributes, and they will do wonderful work on your tributes to commemorate whatever you want to.
Mr. Speaker.
Thank you, Madam Speaker Pro Tem, and members, you can be seated. Thank you to our front desk staff. Remember, there was a sort of a change from resolutions to tributes a few years ago, and it is fun to have a tribute to a tribute. So I hope if you guys want a copy of it, you can come up and get your own copy to take back to your districts. We're happy to sign it. Luckily, we don't have to vote on it. You don't have to co-sponsor it. It's just a tribute to a tribute.
Thank you. Representative Geithner.
Thank you, Madam Speaker Pro Tem. I was just wondering if Tenacious D had a hand in writing this tribute to a tribute.
Any other announcements or introductions? Representative Luck.
Thank you, Mr. Speaker. It's very hard to follow such a wonderful tribute, but I'm going to try. So it is Friday. Representative Sandridge filled out one of these, and he just wanted to say that he was thankful to see all the kids this week, and it was great to see all the kids this week. It is day 80, which means that we are 2/3 of the way through this session, and it is also the time of year when we spring clean. And it just occurs to me, a lot of things are said and done in this building that can allow junk in our own spirits towards each other and towards ourselves, actually. And so I just encourage us this weekend and next week to, embrace forgiveness and embrace love for each other and for ourselves and for those in our districts. I know it is easy to take offense, and I just pray that we are able to spring clean a little bit in that regard and finish the year well in the last third. So with that said, as always, you all are inherently valuable and loved and worthy and adored, and I truly love seeing you every day and can't wait to see you again soon.
Thank you, Representative Luck. Further announcements and or introductions? Seeing none, Majority Leader Escar.
Thank you, Mr. Speaker. Members, thank you for your work today. Although it was April Fool's Day, thank you for the shenanigans that made us smile. Some of us make our eyes roll. We appreciate it so much. Have a fabulous weekend. And with that, I move the House stand in recess until later today.
Have a great weekend, everybody. See no objection. The House will stand in recess until later today.